percentages you'd like that beneficiary to have.
Now, I know that in New Jersey there's a separate law that you can put a clause in a will which permits you to list the personal property and I guess some accounts separately on a separate piece of paper that you can change from time to time without the formality of executing a new will. It's in the statutes, and frequently what I will do is, because I've written a few wills in my day, is include that clause and then on a separate piece of paper have them make a list, sign and date it.
That's correct.
Right? It's funny, I tell clients like that, it's a good idea because if you've left, let's say your fishing rod, your fly fishing rod and your, and special things to people, and they annoy you at some point, you can scratch them off and put something else in its place without going back to a lawyer and re-executing your will. But it's a good tool, I think, to have when you're making a will. What are the typical specific bequests that you see in wills? Or is there such a thing as a specific bequest?
I don't think there's really anything such as a specific bequest that I see overall, other than you'll see people want to leave to a charity. Mm-hmm. So there'll be a specific request of a certain dollar amount to a charity. Or more importantly, if they have something that's of value, jewelry, collectibles, right, antiques, certain specific items that mean something to them as far as sentiment is concerned, and they want a specific family member to have that.
All right, now let's talk about clauses regarding spouses and children. Okay? In a will, is there some significant trend that you've seen leaving things to the spouses? Most people leave everything to their spouse?
Usually the trend is they leave everything to their spouse and then to the surviving children.
Okay. Now, there's a couple of different ways to leave things to children or to the secondary beneficiaries, or the contingent beneficiaries, I guess they're called, right?
Correct.
What are the different types of ways to do that?
Well, there's usually two different ways that are primarily common. One is called per stirpes, one is called per capita. And what that is per stirpes sort of leaves the class open. So for example, let's say you make a will, and at the time you make a will, you're married and you have 2 children. And you say, now's the time to provide for my children, my family, etc.
Right.
And somewhere after you've executed the will, you maybe have another child or 2 children. So if you put in there, I leave it to my spouse, and then if she predeceases me, to my children per stirpes, what it will do is it will give it to the class, meaning your children. And even though you had 2 children that were born after you had the will, they will each take equally.
Now, you didn't know that I went to a parochial high school and took Latin.
No, I did not.
Please
don't ask me what that means.
Per stirpes, translated into English, I guess means through the stirrups or through the bootstraps. And what it connotes is that the beneficiary further down the line, if somebody up higher on the line predeceases, they stand in the shoes of, or in the stirrups of.
That's correct.
All right? So, for an example, if there were 2 children who were to receive them, and one of the children had 2 children, right? And that child who had 2 children predeceased, those 2 children, grandchildren, would take the deceased child's share.
Correct.
Right?
And they would share the deceased child's share equally.
Right. Correct. Now, that's per stirpes. Now let's go to per capita.
Per capita is based on the actual number, or the actual people that are there. So if, using the same example, you had 2 children, you executed a will, you named your 2 children per capita, and maybe had 2 children more, then the 2 children more would not take because they were not named in the will. Or in the example where you gave, where there was a deceased,
right,
what would happen is it wouldn't go equally to the 2 children of the deceased. It would actually stay in with the main child that was still surviving.
What do you see more of, per stirpes or per capita?
Per stirpes, definitely.
Yeah, I would agree with you. That seems like a natural flow to an estate.
I think so. Most people, if they leave to their children, they want their children's children to take their share if something should happen.
What about the spouses of children? A lot of people come in and say, I don't want the blankety blank to get any share of the estate because the marriage is no good and I don't like that person. How do they protect against the spouse of a child getting an inheritance?
Well, you can put a specific disinheritance clause that in the event that my child predeceases me, her share or his share does
Right.
not go to the surviving spouse, and I specifically disinherit them. And then if you don't provide for a contingency, then that would be one of the places where the bequest fails because that person is no longer there and would become part of the residuary estate.
Okay, well, that makes sense. How about if a beneficiary is under the age of 18, a minor? What kind of clauses do you recommend?
Usually what I do if they're under the age of 18, and I actually like to go to 21 myself,
Okay,
I suggest that you do what's called a testamentary trust within the will. And what that does, it provides for a trustee to be appointed to take over the bequest of the minor children. For example, if there's money, then it would go in the name of the trustee for the benefit of the name of the child and or children as the case may be. And then what you do is you set specific guidelines for when that child and or children are entitled to receive that money. And a lot of times I will recommend not a full distribution when they turn 18 or 21, but rather staggered distributions because we all know when we're 18, 21, our sense of responsibility may not be that as when we're 30 or even older.
now in the testamentary trust, there are provisions, aren't there, that will permit the the trustee to distribute money either from principal or interest for certain purposes.
Correct.
And what would be those purposes?
Usually the clauses that I see most importantly are for education, medical expenses, if they have some specific trade they're looking to do, things of that nature.
All right, so you can have, let's try to summarize this and sort of make it easy to understand. Everything goes to a trustee, and it's distributed to the beneficiary at, like, let's say 18 or 21 or 25.
Right.
But even though the trustee is holding the money till then, they can still invade the principal amount and interest that's earned for special purposes that you've just
Correct. For
mentioned.
example, if someone goes to a private school, let's say they're going to a private school, you have a 13 or a 14-year-old high school student going to one of the local private schools where tuition is paid and something happens to the parent or parents. The trustee would then, under that trust, would be entitled to draw from the principal or interest to continue that child in that parochial or private school, whatever the case may be, up until the time that they become of age to receive the bequest themselves. Or if they had a serious illness that was not covered by insurance or portions thereof, the trustee would be able to pull from that to take care of their medical coverage.
Okay. Now, what about the people who administer the will and the trusts? Are there clauses appointing them?
Yes.
Okay. And could you let's start with the executor or executrix, right? Can you describe who those people are, what their functions are, and who you should select?
Well, the executor or the executrix, depending on whether it's male or female, is the person that you appoint to basically administer the estate. That means they go out, they locate the assets, they collect them, they open a bank account, they sell property on behalf of the decedent. They're the person who basically steps into your shoes and signs the documents necessary to effectuate the transfer of the bequest under the will.
Okay.
Normally what I recommend, as far as if you're asking who to appoint as an executor or an executrix, is first and foremost you have a close family member, perhaps a brother, a sister, or if your spouse is still alive, you may actually ask for your spouse to be reciprocal executor and executrix for each other's will.
Right. That makes sense.
If there's no spouse, if there's no children, maybe a trusted relative, a close friend, somebody who knows you, who knows your wishes, and knows how you would act pretty much under a given set of circumstances, or is pretty familiar with how you would act.
And I suppose you would also want somebody who's, trustworthy and has good business sense, and that you can trust to take care of the funds and the administration of this estate.
Presumably,
Right.
yes, you would want someone of that nature.
I mean, there are some people who have good friends, but you wouldn't trust them managing your portfolio.
Correct.
Right? So you want somebody that knows how to do that. What about age?
I always say it should be someone relatively close to your age or younger, rarely ever older, because the natural course of nature is that the older you are,
Sure.
the less likely you are to survive the younger person.
They should also have like a alternate, right?
Correct.
And that would be, I guess, someone down the line that, in the event the one person was unwilling to act,